We now have in front of us item 14I. Item 14I is Ordinance AO 2017-84, an ordinance of the Anchorage Municipal Assembly, adding a new section to Anchorage Municipal Code, Chapter 8.65, to provide immunity from prosecution for certain persons allegedly engaged in prosecution when they report serious crimes and cooperate with law enforcement. Public hearing on this item is now open. Anybody wishing to testify, please come forward, state your authority for the record, and spell your last name. You'll have 3 minutes. And tell us what part of town you live in. Welcome to the meeting, ma'am.
Hi. My name is Amber Batts, B-A-T-T-S. I'm testifying in support of this ordinance today. I've worked off and on for 10 years in Alaska's sex trade. For several months when I was working, I would get a call from a gentleman, always asking about procuring a minor for sex acts. I was not able to contact any authorities about this guy. Instead, I was only able to put him on Craigslist to let other people know. If this ordinance was passed back then, I would have been able to contact the police, and he wouldn't be in our community still victimizing Anchorage children. Please vote yes on this ordinance.
Thank you, ma'am. Questions from Assembly members? Don't appear to be any. Thank you.
Yep.
Anybody else wish to testify, please come forward.
Hi, my name is Heidi, H-E-I-D-I. In 2004, I was working for a violent pimp, Jerry Starr. He had a hit on me and 3 other people, and if this was passed, I would have been able to come forward and be able to help. Instead, I had to tell people I didn't even know her. Please pass this bill.
Thank you. There are no questions. Anybody else have a statement they'd like to make? Please come forward and testify. Welcome to the meeting.
My name is Crystal Godby. I'm with the Community United for Safety and Protection. I'm testifying today in support of Ordinance 84. I worked as a sex worker for 3 years. I didn't do it because I liked it. I did it because I was homeless and I was a drug addict, and I've been clean for 17 months now. I'm going to read you a list of names of sex workers and sex trafficking victims who have been murdered in Anchorage in the last 14 years, whose cases are still unsolved. Desiree Lekanoff, murdered. Michelle Roth, murdered. Jessica Lake, murdered. Tanisha Bobo, murdered. The following sex workers or sex trafficking victims are currently missing: Sierra Roberts, Marianne Alexi, and J.L. Hamilton. All these women were probably murdered by repeat violent offenders who have already been reported to police and arrested for other crimes against sex workers before they murdered Alaska women. In this ordinance, if this ordinance had been in place back then, these women had colleagues and coworkers who may have been witness to their murders or have been victimized by the same predator. Please vote yes on this ordinance and incentivize victims and witnesses to come forward and to make reports that these murders can be brought to justice and the people of Anchorage can be safer. Thank you.
Thank you. There are no questions. Anybody who wishes to testify, please come forward. Welcome to the meeting.
Hello. I'm short. My name is Vered Maris. That's M-A-R-E-S. I am the owner of the Future Writers Block Bookstore and Cafe on Spinard Road, starting construction. I'm actually here to testify or to give testimony on behalf of a woman who wishes to remain anonymous. And so I'm going to read her statement to you, and then, of course, if you have any questions, I'm happy to try and answer them. She writes, "Dear Assembly members, I am writing in support of this ordinance. I am trying to stay anonymous because I am worried about being further marginalized and discriminated against. I was the victim of violence and hope everyone will respect my privacy. Last year, I was assaulted in the lobby of a hotel. The employees called 911 at my request while I was yelling for help. But the police came and reviewed the video footage of me being assaulted, and they charged me with prostitution instead of charging the man who assaulted me with assault. I am not even a prostitute, but the man who assaulted me told them I was. I believe that I was treated as less than because I'm an Alaska Native woman. It's astonishing that in this day, Natives are treated differently by the police. I never imagined that while I was screaming for someone to call the police and help me, that I would be the one prosecuted. It caused me a lot of anxiety and panic attacks because of this charge on my record and the stigma associated with it. The man who assaulted me didn't even get charged with assault, and his prostitution charge was dismissed by the prosecutor. It is outrageous. It makes me leery of the police, and I will no longer call the police for anything. Please vote yes on this ordinance.
Thank you.
Thank you.
No questions. Anybody else wish to testify, please come forward.
My name is Tara Burns, and I'm with the Community United for Safety and Protection, and I'm testifying in favor of this ordinance. When I was a teenager, I was sex trafficked in Fairbanks for several years. The women that I worked with tried to help me, and one eventually did help me run away, but none of them felt safe going to the police and reporting my victimization. Since that time, I completed my graduate research at UAF on the lived experiences and policy recommendations of 48 people with recent experience in Alaska's sex trade. I now travel all over the world consulting and speaking about prostitution and sex trafficking policy and research. 52% of the people that I consulted in my research had tried to report being the victim or witness of a crime to police. A third reported that they were threatened with arrest, and 6% were arrested while trying to make a report. Of the sex trafficking victims consulted in my research, 80% had tried to report a crime. 60% said that they were threatened with arrest, and 20% were actually arrested while trying to report that they had been the victim or witness of a crime. 72% of research participants said that they had been the victim or witness of a serious crime that they did not report to police. When people in the sex trade do not report violent crimes, repeat violent offenders and even murderers are allowed to remain free in our community to prey on our most vulnerable citizens of Anchorage. We need good policy to incentivize the reporting of heinous crimes and make Anchorage safer. I've had some personal experience trying to report predators in our community. I've tried to use the Crime Stoppers website to report anonymously, but police are not able to get warrants to further investigations based on anonymous tips. A prostitution charge is not just a Class B misdemeanor. When people are charged with prostitution, they lose their livelihood. Sometimes they lose their housing and their children, and they face discrimination in accessing housing, employment, and child custody for the rest of their lives. Almost identical language was amended into the state prostitution statute as part of SB 91 last year. I've previously provided you with a press release from the Department of Law regarding a sex trafficking arrest just a couple weeks ago in Anchorage, where they suspected that the perpetrator had multiple victims going back over a decade. In their press release, the Department of Law was able to use the new section to encourage more victims to come forward, informing the public that Alaska state law would protect victims coming forward from prostitution charges. But we cannot currently say the same of the Anchorage Municipal Code. In the substitute, there's a new clause saying that the report must be within a reasonable time of the commission of the crime. And I'm concerned that that could prevent people who may have information about the unsolved murders and missing persons cases of sex workers in Anchorage to not come forward and report when this passes, because some of those murders are quite old, but these victims still deserve justice, and witnesses should be able to report. Please vote yes and support victims in Anchorage being able to report heinous crimes so that we can all be a little safer.
Thank you, ma'am. Mr. Croft. Mr. Croft, sir?
So thank you for your testimony and your continued activism in this area. I guess I'm trying to figure out whether this is a specialized area where this rule should apply, or whether it should apply more generally to other areas of lower level crime where somebody witnesses a more heinous crime. So people using drugs and somebody overdoses and they, or somebody sees a violent crime as a part of that, thefts where something. So I guess what I'm asking you is it an aspect of this being so specialized, the victims here being in so much danger that makes this, or is this something we should replicate in a lot of different areas of criminal law?
Well, Alaska state statute does already protect drug users who call 911 to report an overdose. Prostitutes have been targeted for murder and violent crime for a really, really, really long time. We have had, serial killers preying on prostitutes for a long time. We had Robert Hansen here in Alaska, who was able to go on killing prostitutes for years after one of his even after his victims had reported him to police. So prostitutes are a group that are regularly targeted for violent crime, and currently there is a perception that people can target prostitutes with impunity, and so we're just calling on our leaders to take a leadership role in telling people that it's not okay to murder us, and that we will be able to go to police and make those reports.
Mr.
Thank
Croft?
you. No,
Thank you. Mr. France, ma'am?
Thank you for your testimony and for the important work you're doing in this area. You had mentioned something about a concern about the time frame, and I didn't catch your question.
So there's the substitute has a clause that says that they have to report in good faith, which is good, within a reasonable time of the commission of the crime. So I'm concerned that, there are currently 11 unsolved murders and missing persons cases of sex workers in Anchorage just within the last 14 years, I believe, and that people, when this passes, people who have information about a murder should be able to come forward and report that without fear, even if it has been maybe 14 years. It's been 13 years now since Michelle Roth and Desiree Lacknoff's disembodied torsos washed up on Beluga Point, and they deserve justice.
Thank you.
Is that all, ma'am? Mr. Dunbar, sir?
Well, just really quickly on that point, I assume, and Mr. Falsey, I don't know if you're able to answer this, or maybe this will come up later, maybe some of the police office, one of the police department, but isn't there a statute of limitations on the crime of prostitution? So if someone had evidence about a murder from 10 years ago, and that was when they were engaging in prostitution, wouldn't the statute of limitations have already run?
Through the chair, my understanding is that, yes, the statute of limitations would have run after a certain period of time. I don't have top of mind what that statute of limitations is.
Okay. So I certainly hope that people do have evidence on those murders that they come forward. Thank you, ma'am.
There are no other questions, ma'am. Thank you for testifying.
Thank you.
Is there anybody else who wishes to testify on this item? Anyone at all?
Hi, my name's Ed Larrivee, Larriv, is Victory -2. I live in the area of Tudor and Lake Otis. And with this, I think that anybody who commits a low-level crime or just crime in general should be able to point the finger at the person that's committing a crime, just not, and to the cops, not just for prostitution, theft, even murder, because they're all crimes against society. And if, as it sits right now, I think that in order to pass this, you ought to legalize prostitution, because that way it'd be monitored, there would be less people dying, getting their heads chopped up. I knew a guy that once killed prostitutes. I used to buy donuts from Bob Hansen back in, the 80s. And, we talked about hunting and stuff. And he looked at them like that one gal said. He looked at them as targets, But you wouldn't know that from talking to him. I thought we were talking about animals, hunting animals. And he was quite a character. Yeah, I can understand why the cops didn't go for him, because he was a skinny guy. He looked like a librarian. He was about that tall, blonde hair. His wife would tell him what to do, in the shop. And he'd give out free donuts. She really liked that. But I mean, this guy looked like he would never harm a flea. And, these women, they have to deal with these types of characters. And so maybe legalization of prostitution might be the case before you pass anything like this. Because if you pass this, you should also pass other people that commit crimes so that when they testify or when they point at somebody and say, yeah, he did this, the cops can't arrest them either. And also, if what if the guy's a thief and a prostitute? Okay, if you can't prosecute the prostitute, then that guy might survive the ordeal and learn to steal another day. So that's something to think about too. Well, anyway, my name's Ed Larrabee. That's what I think.
Thanks for being here, sir.
Thank you.
Anybody else wish to testify? Please come forward and give us your name, spell your last name, tell us where you live. Hearing and seeing no one, public testimony is closed. The votes wish to the body. Mr. Rivera. Move the S version, sir.
Thank you. Move to approve the S version.
Second.
Give me a second. Felix?
Thank you, Mr. Chair. Briefly, this ordinance is a simple change to code that mirrors recent state statute changes to provide immunity from prosecution for persons allegedly engaged in prostitution when they report serious or heinous crimes. I want to quickly cover some of the areas of concern brought up. So first, this slippery slope argument, why only prostitution, what's next? I think Ms. Burns covered that a little bit, but the scope of this ordinance is intentional. This AO addresses a specific community with a history of victimization and a history of distrust with law enforcement. As we've heard just now, there are times when an alleged sex worker might want to report a crime to APD, but the individual is nervous about repercussions. This allows an avenue for these workers to do the right thing. Second, amendments have been made in the S version, as well as an amendment Mr. Traney has, to address the vagueness in certain phrases, specifically cooperation with law enforcement and evidence supporting the prosecution. I want to thank Assembly Council for working on these amendments and making our version of the law even better than the state's version, if I say so. And to wrap up, this ordinance seeks to provide an avenue to build lost trust between this disaffected community and law enforcement. It should be noted that 20 other states have laws with this immunity language, and an additional 11 states provide for an affirmative defense. Jurisdictions around the country have implemented these laws successfully. Thank you to CUSP for your help developing this ordinance, and I urge my colleagues to support. That's it, Mr. Chair.
Thank you, sir. Mr. Constant, sir.
Yes, I would really appreciate if we can hear from the Deputy Chief Gillum on this subject.
Deputy Chief? This is only to help you make a decision, sir. Normally we don't ask other people, but if you want that to help you make a decision, more than happy to bring people up. Chief?
Good evening, Chair, Assembly members, and congratulations to some of you. I've been out for about 5 weeks, so welcome aboard there. How may I help you this evening?
So, Chief, what do you think on this? What are your impressions on the S version?
I will tell you that as a law enforcement officer for almost 38, 39 years, I can tell you that I have some concerns. I will agree that they are at high risk. There are some issues. I do know that we do have Crime Stoppers. I did ask about how many prosecutions we've had. In the last 18 months, there's been one that I was reported to. So I think it warrants more study and maybe a little caution, because I'm sorry, I don't remember which one said it, mentioned, the slippery slope of other. I mean, if we're going to do this for other minor crimes, are we going to do it for drug dealers? Are we going to do it for someone else? So I would just ask to be cautious and be a little more involved.
Okay. Mr. Constant, question, sir?
Yeah, I understand from my friends in law enforcement they have some concerns. Can you be more specific about what your thoughts on what might go wrong?
Well, I think the ordinance as written is a little bit ambiguous. I think you could get into child pornography questions and some other prostitution crimes that would be quite serious. And I'm a little reluctant to say we give somebody a pass, especially this window of opportunity. Are they only going to tell us when they get arrested? Is there going to be some type of a requirement, that if you're engaged in this activity, that's why I'm asking that we be a little more cautious about how we're going to implement this.
Anything else, Mr. Constant? Okay, thank you. Chief, I don't know if they're going to, I got other people on here, so you might want to stay there or not. We'll see what happens. Mr. Peterson, sir, do you have anything for the chief?
Thank you, Mr. Chairman. Not at this time. I actually was wondering if Mr. Falsey could tell us if the Department of Law has a definition of what a reasonable amount of time is. It says, report this to law within a reasonable amount of the commission of the crime.
Through the chair, a reasonable amount of time is left to a case-by-case discretionary call. There's no arithmetical formula, and this ordinance certainly would not put a number on that reasonable time window.
So in some instances, it could be a few hours, and in other instances, years?
Through the chair, again, I suspect it would depend on the facts of the various cases. Perhaps if someone were only to learn of a serious felony after some length of time had transpired from when the felony had been committed, perhaps that could lead to a relatively large window. But again, there is no objective measure.
Thank you.
Thank you. Mr. Dyson, sir.
On your right.
Thank you.
Yeah, I was just thinking about the very thing you mentioned. So somebody that had been around the crime and then realized there was an active investigation and they might be picked up as an accessory could pick up the phone and call in and demand immunity under this situation. That's the kind of thing you're thinking about, isn't it?
Mr. Dyson, through the chair, yeah, absolutely. That's one of my concerns.
Yeah. Has the department and hopefully maybe the prosecutors had a chance to review this? Has there been any analysis in your shop?
Mr. Dyson, through the chair, yes, there has been some discussions. Unfortunately, I was out for a while, so I don't know all the depth of those discussions, but it has been reported to me that there are concerns.
All right. Thank you. Mr. Falsey, have your prosecutors thought about this one and reviewed it?
Through the chair, Assemblymember Dyson, the answer is yes. Unfortunately, Seneca Atheno, our municipal prosecutor, is out of state for a training now, but she has conveyed to me a number of thoughts along the lines from what you heard from the deputy chief, that we do have some systems in place now that could begin to address this concern. So the Crime Stoppers option allows you to report crimes anonymously and actually allows you to reap a small financial award if that ultimately leads to a felony arrest. That it is unusual to pick a single crime to offer this kind of immunity and leads to what has been characterized as a slippery slope kind of questions. If I witness someone caching child pornography while I'm in the middle of robbing their house, should I have a similar level of immunity? And I think it is fair to say that generally the prosecutor's office, and you can make this of it what you will, is always going to be protective of prosecutorial discretion, that the prosecutor's office itself conceives of its line of business as taking into account the various equities, and as a practical matter, there just haven't been a lot of prostitution prosecutions in recent memory. We are aware of only one in the last 18 months. It was brought to our attention, as I understand it, on the report of a hotel employee who heard a scuffle and there was an alleged robbery involved. I think there is a bit of a sense from the prosecutor's office that this may be a solution in search of a problem, but at the same time, it wasn't reported to me that it would be so disruptive to the municipal prosecutor's business that this is one that we would need to throw our bodies down in front of the tracks.
Mr. Dyson?
I certainly provide better support to this.
Move this version forward.
What I understood it is for the prosecutor, the sex worker.
Amy, would you move the microphone closer to Fred, please?
Who's being beat up or threatened or so on, to allow that person, he or she, to report without incriminating themselves on it. As this thing is written, do you understand that it's not just when the reporting person here is under threat, that it's far more general than that?
Through the chair, yes. So there is a potential distinction to be drawn between crimes that have been committed against the person allegedly committing prostitution themselves and other crimes that have merely been witnessed. If you were to look at page 2 of the ordinance, section 1 would say that a person accused of the crime of prostitution may not be prosecuted if the person witnessed or was the victim of and reported to law enforcement any of the following crimes. Crimes against the person, which is that first category A, those are largely felony-level assaults, as I recall. Assault, stalking, abuse of a child, neglect of a child, harassment, sex trafficking, sexual exploitation of a minor. It's that first distinction between being a witness of or actually being a victim of, which would allow you to get into the scenarios where you could say that I had simply witnessed bad behavior that I was not directly involved in.
Mr. Dyson, anything else, sir?
Yes, thank you, Mr. Chair. Mr. Falsey and to you, sir, if we delayed action on this a bit, could you get back to us with perhaps solutions that eliminates this problem to both of you?
It is always the case, through the chair, that if you were to refer an ordinance to us for some additional study, that we could propose some additional amendments or language that may assuage some of our concerns.
Yeah, and not to be critical, I wish we'd heard, from both of you all before we got here. Perhaps we did and I missed the link, but thank you.
Thank you, Mr. Dyson. Mr. Wilton, sir, on this issue.
I just want to be clear, this would only give immunity for crime of prostitution. Is that correct? To whoever can answer that.
Through the chair, that is my understanding. So a person accused of the crime of prostitution under our immunity code could not be prosecuted for that crime if. So yes, it would only be a waiver for that particular ordinance.
And then I guess for Deputy Chief Gillum, so there was only one prosecution for prostitution in 18 months? Is that what you're saying?
Through the chair, Mr. Wilton, that's correct.
Okay, and is that because we just don't have prostitution in Anchorage, or because it's just not a priority for you, so you don't go looking? It's not.
It is not a priority.
Okay.
Anything else, Mr. Wilton?
I'll be pondering. Thank you.
Okay. Mr. Dunbar, sir.
Thank you, Mr. Chair. Well, I certainly will respect the wishes of the sponsors if they all decide to postpone this, as Mr. Dyson suggested. My inclination is to go forward with it tonight, and I'm certainly in support of this ordinance. My first question is to the administration, to you, Mr. Falsey. So Ms. Burns raised the issue about the reasonable time language on page 2, section 1, line 3. Why do we have that in there? I mean, why do we care what time they come forward with that evidence? I guess you can make an argument about it being, sort of fresh, right, in their recollection. But other than that, these are serious crimes. Why do we want to put a time limit on when they could come forward, regardless of whether they had engaged in the crime of prostitution in the past? Again, if we kept the good faith language in there but took out reasonable time.
Through the chair, I think there are at least two animating reasons for having a reasonable time reporting requirement. The first would be because I don't understand that it was the intent of the author to say that a person who's engaged in prostitution could witness a felony-level crime and keep it in their hip pocket in case they are ever actually busted for prostitution, and then and only then report it. That the notion was, if someone has seen something that is so egregious that it really should accrue to this kind of immunity, we want to waive the prostitution because we want that other element revealed immediately, that you would have a more quick turnaround on the reporting time. And the other is, I think, in the absence of any time limit, then taken quite literally, a person who would be arrested for prostitution could report significant assault that, they got into a scuffle with their sibling in 1983, and that in theory is a crime, and there would be no real sideboards to that. So I think those are the two animating concerns, as I understand it.
Right, and in that latter case, we couldn't pursue a prosecution anyway because the statute of limitations would have run on that other crime.
Yes.
Right. Okay. Thank you, Mr. Falsey. May I ask a second question, For you, Chief? You had alluded to the fact that maybe this could somehow bleed over into the crime of child pornography, but it seems very clear here that says crime of prostitution. Could you elaborate on that? Why do you think this might impact child pornography?
Well, if, through the chair, Mr. Dunbar, if someone had witnessed child pornography or participated in some effect, and then they get arrested for prostitution, they may use that as a mechanism to get out of the prosecution.
Maybe I'm misunderstanding how this works, but my understanding of this ordinance is it keeps them from being prosecuted for the crime of prostitution, not for another crime they might have committed. So if they were...
Or witnessed.
Okay, but if they are the one committing the crime, it doesn't matter if they witnessed it or not.
Child pornography could be someone participating in filming of minors, in sex trafficking or others. They may be involved in something. They may not be arrested for that, but they can come forward and say, well, I'm aware of this crime, so therefore I don't want to be prosecuted for prostitution.
Okay. Do you have any comment on that, Mr. Falsey, on that interpretation?
Through the chair, I'm not sure I completely followed that question. I might need a little bit more meat on those bones.
All right. Thank you, Mr. Falsey. Thank you, Mr.
Thank you, sir. Ms. Dembowski, ma'am.
Thank you, Mr. Chairman. Through the chair, Mr. Falsey, in the sponsors whereas clauses, though I may take exception to some of their commentary, I will go straight to some of their reference to SB 91, and I'm not familiar in SB 91 off the top of my head with provisions in that bill that basically won't prosecute somebody for prostitution, say, if they witness another crime. That's not in SB 91, is it?
Through the chair, I think actually it is accurate to say a provision very much like what is characterized in the whereas clause is in SB 91. We previously mentioned that when a request to include something similar in municipal code was raised maybe a year and a half ago now. The language of the state law we think is actually much more problematic than what's being proposed here. It is now that a person may not be prosecuted for prostitution if, one, the person witnessed or was a victim of and reported to law enforcement in good faith one of the following crimes, and then there is a very long laundry list of serious crimes. Two, evidence supporting the prosecution of the section was obtained or discovered as a result of the person reporting the crime, and three, the person cooperated with law enforcement personnel. So it begins in the same place as what's being proposed here, but some of the additional considerations that have resulted in additional bells and whistles and language changes in the municipal ordinance are addressing concerns that we think were not maybe fully anticipated with the SB 91 language.
Okay,
but to get to your question, yes, the SB 91
so let's break it down to English because it's getting late and I'm a little tired. So my understanding from what you just said is basically SB 91 already says this is basically the rule. If somebody is busted for, they report a crime and they were engaging in prostitution and they report a more serious crime, basically you're telling me SB 91 says they can't be prosecuted for prostitution.
Through the chair, under state law, but there's nothing in SB 91 that ties our hands.
But under state law, so you're saying because prostitution is a misdemeanor, Class B, isn't it?
Through the chair, I'm not sure what it is under state law, but our code, yes, it is a misdemeanor. And the SB 91 provides this immunity only from prosecution under the state statutory provision, but not under municipal ordinance.
So what I'm trying to reconcile is the city can be more restrictive than the state, but not less. So if state law says you can't prosecute for somebody for this situation, how is it the city law can?
Through the chair, in this case, the municipality, as a home rule municipality, can legislate in any area that is not expressly forbidden to it. So, for instance, we have certain crimes on our books that are not mirrored in state law at all. So, synthetic opioids, we made distribution, sale, possession of those a crime. That is not found anywhere in state law. In the same way here, there's nothing in state provisions that I'm aware of that says that we have to prosecute prostitution in exactly the mirror image of how the state prosecutes prostitution.
So what you're telling me is, in this particular case, city law can trump state law.
I think
when it comes to prosecution, which is exactly the opposite of how I understand it.
Through the chair, I think in this case it would be more accurate to say that we are both allowed to maintain our own independent systems. We don't tell the DAs what to do, and the state, in this case, has not elected to tell the municipal prosecutors what they have to do.
Mr. Bowski, anything else, ma'am?
No.
Mr. Rivera, sir. On the S version.
Yes, thank you, Mr. Chair. So just a couple of questions for Mr. Falsey. Could you, in the ordinance, it states under Section 1, the person witnessed or was a victim of and reported to law enforcement in good faith. Could you define the term good faith and what a good faith report entails?
Through the chair, if you wanted me to do a quick Google search and give you the Black's Law Dictionary of Good Faith, I would be happy to do that. I think it generally incorporates the equitable notions of having clean hands and acting without an improper motive.
Thank you, Mr. Falsey. So then, in that case, if some examples have been brought up today of potentially someone, alleged sex worker who in their back pocket holds another crime that they may have committed, then this good faith report and the need to have a good faith report, I think, handle some of the issues that were brought up, I think, by the chief. Second, statute of limitations, specific to the previous murders, Mr. Falsey, if someone is a current sex worker in current law, they would not be able to come forth with evidence regarding those previous murders without fear of prosecution.
Through the chair, my understanding is that is not the case, that at least through the Crime Stoppers mechanism, one can make an anonymous report of felony level activity.
Thank you, Mr. Falsey. And then just one last point on the sort of the lack of prostitution prosecutions. That's a very different issue than what's trying to be handled here, which is bridging the trust of alleged sex workers. We've heard examples today of people who wouldn't report regardless of whether the prosecutor would or would not prosecute, just because there is that level of distrust between the sex worker community and law enforcement. So this is a way, again, to build that trust. Mr. Chair.
Thank you. Mr. Croft, sir.
We're pestering Mr. Falsey, but I have more. There seems to be an assumption when I looked at it and in the testimony and I think in the things that have been said about it, that there's some relationship between the prostitution charge and the things you saw. But I've been looking, I can't find that requirement. That is, I can say when charged with prostitution, I saw an assault yesterday or a month ago or a year ago that was just on the street or anywhere, right? It doesn't have to be connected to my status as a prostitute, does it?
Through the chair, I also do not see that anywhere in this ordinance. It appears that you could report any felony activity, however you saw it, wherever you saw it, whether it's connected to your own prostitution activities or not.
So in that sense, anything I witness, I don't want to report. I'd like to keep it for my get-out-of-jail-free card. If I'm ever charged with prostitution, I can say I witnessed an assault, and I want to tell you about it now that I'm being charged. The reasonable time is that limit, so I couldn't wait too long, but I could just, all these things I see. And the other thing that still seems to me there, though, of limited danger is, it says witnessed or was the victim of. Somebody who was the perpetrator of these crimes could also use this if they would witness it as well. It doesn't say but not perpetrators. And I do think that isn't that dangerous in the sense that you're not going to confess to a more serious crime to get yourself out of prostitution. But is that right? You would have the ability to say, well, because I told you about this assault I did, you can't get me on the prostitution charge.
Through the chair, I think that technically would be right. The perpetrator would be a witness for purposes of those prosecutions. And I suppose even though you wouldn't have an incentive to report a greater criminal activity if you were charged with a greater criminal activity and prostitution, perhaps, I'm trying to think through that scenario. I'm wondering if both crimes were potentially coming to you, whether you couldn't proactively report that you committed the larger crime to blunt the second prostitution charge. I don't know. I haven't thought that scenario completely through, but I agree that that is a potential ambiguity.
Yeah, thank you, Mr. Chairman.
Okay, there appear to be nobody's ready to discuss anything else. Before we vote on this, is there any other motion anybody wishes to offer? Mr. Domowski.
Mr. Chair, listening to the testimony, I came in this with an open mind, thinking I was leaning towards voting for this, but I'm hearing a lot of ambiguity coming from the Department of Law, and I really wish Seneca was here, since she's the prosecutor. So I think, I hate to say this, Mr. Falsey, but after listening to you, I'm more confused now than I was when I started. So for my own benefit, I will just ask that, when is Seneca going to be back?
Through the chair, I believe she's back. If not next week, I believe it is next week, and I too wish she were here.
Mr. Falsey, from the Department of Law's perspective, in an opportunity to have Seneca weigh in, maybe just help educate me, would it be more appropriate the June 27th meeting or the July 11th meeting?
Whatever you, yeah.
If we can get the votes to get it to come back.
Well, all things being equal, I think I always would prefer, the department would always prefer a little more time, so I would pick the latter of the dates.
Okay.
Mr. Domowski, before you make an amendment, ma'am, we do have another amendment down here, and then we'll come back to you on your motion to postpone, okay?
Okay.
If you don't mind. Mr. Croft?
I don't mind.
Yeah, Mr. Chairman, I'd move amendment number 1 that's been passed out to the S version.
Does everybody have it?
I'll second that.
And under debate?
I'll second that.
Everybody got a copy of it?
Oh, sorry. Mr. Chairman.
Go ahead, Mr. Croft.
Everyone has found the amendment. It really attempts to provide more clarity in the definition of cooperates with law enforcement. It was actually Chairman Traney's discussion, though I had a similar discussion with Ms. Thino before she left about the need for clarifying it. What it does in that operative section of Section 3, so it would still read, at the time of reporting the crime, the full thing is, the person cooperated with law enforcement personnel concerning the crime reported at the time of reporting the crime and continued to cooperate either until the close of the investigation of the reported crime by any law enforcement agency or the conclusion of any prosecution of the recorded crime, whichever is later. And then instead of that, for purposes of, it provides that middle definition. So that's the part that's new, the underlined, non-bolded. And I'll just read it. A person cooperates with law enforcement for purposes of this section if the person initiates the contact with police during which the crime is reported, the person is forthcoming with information to law enforcement, the person is responsive to law enforcement questions and remains responsive to such questioning throughout the investigation, and the person testifies at any evidentiary hearing or trial if requested to by the prosecutor. And then that last part, for purposes of, is deleted. It's no longer needed. And in addition, the person may not have knowingly engaged in conduct that would satisfy these other crimes stays. So a little confusing in its underlining and capitalization and bolding, but it provides more clarity, I think, in that middle paragraph, middle non-bolded underlined, as to what cooperation with law enforcement is.
Is there a second on that?
Second.
And this comes from Seneca, by the way, if you want to know where this came from. The prosecutor.
I seconded it.
But moved to second, Mr. Wilton seconded. Okay.
I think we've been through that already.
Oh, okay. I'll third it.
Okay.
Yours.
Any more discussion, Mr. Croft, on your amendment?
I've got a comment.
No.
Mr. Dunbar, and your amendment, then I'll go to John Wilton.
No, I'm sorry. My comment is on the motion to postpone.
Mr. Wilton, on the amendment in front of us.
Thanks. So I can understand the purpose here, and it's fine, but I'm a little confused on the wording here, and it's the third line of your amendment. Initiates the contact with police during which the crime is reported. I don't understand what this during which the crime is reported. During which what?
that you initiate with the police department what you know about a crime that had occurred.
Yeah,
Is that awkward, or am I kind of?
it's a little awkward for a sentence clarifying, but it, I mean, is supposed to capture the idea that you initiated the contact, you started.
They didn't, you did.
Yeah, the police didn't sort of trap you and then you blurted it out. You reported it and you initiate the contact, and the crime there is the crime reported, not the underlying prostitution, so it is the crime you're telling them about.
Should be correct the way it's written, I think. Mr. Wilton?
Still confused by that word during, but I suspect this will all be postponed for a month, and we
It probably will be.
work on it.
Depends on the votes.
So I'll let it go. Thank you.
Okay. Mr. Croft, on the amendment you brought forward, sir?
No, sir.
Okay. Let's vote on the amendment. There's no other discussion. Please vote. That is approved unanimously. Now, Ms. Dombowski?
Mr.
On
Chair,
the document, on this version as amended, ma'am.
yes, sir. Mr. Chair, I move to postpone to the meeting of July 11th.
Second.
It's been seconded to postpone this item till our meeting of July 11th. Moved and seconded. Any discussion, Mr. Dunbar?
Yes, to the motion. I know that Mr. Falsey had expressed a preference for July 11th over June 27th. I guess I would urge that we do it on June 27th instead, and the reason is because I understand that he wants Seneca to get back and to get spun up on this and to do work on this as well. But there is I do think there is a human cost to delaying this an extra 2 weeks, and that is that I think this is a needed reform, and one prostitution arrest in 18 months. So probably in those extra 2 weeks, nothing is going to happen. But we don't know that. And I think this is a valuable law that we need to have on the books. And maybe it needs to be worked over a little bit more, but I think we can do that in 2 weeks instead of a month. And so I would urge that we postpone it to the 27th instead of the 11th. But I think we have to vote on your motion first, Ms. Dombowski.
Mr. Rivera?
Thank you, Mr. Chair. I am in agreement with Mr. Dunbar. We did have Ms. Fino available at the work session to answer any questions on this ordinance, and we've worked pretty extensively with her. It's the main reason why this is so much better than the state law. And if I may, Mr. Chair, I do have one comment not related to the motion.
Mr. Rivera, why don't you just make a motion to postpone it till the 27th of June?
Mr. Chair, I'm happy to change my amendment
and then if
or my
fails,
motion.
go to hers. Ma'am?
I'm happy to change my motion.
Then change it to the 27th.
Yes, I would like to amend my motion. I'm not going to amend it. I'm just going to withdraw it. And I'm going to make a new motion to postpone to the meeting of June 27th.
Second.
Are we all in agreement on this? Please vote. Let me get that. Okay, please vote to postpone this item to June 27th. The vote is 11-0. That is approved. This will be coming back in front of us again on June 27th. Item 11B, AO 2017-84S. We have a motion to approve on the floor. Mr. Rivera, sir.
Move to approve.
Second. We've already got that on the floor, sir. So, for the clerk, make
Thank
your
you, Mr.
motion
Chair.
that you want to do.
Absolutely. Madam Clerk, do we have the documents?
We're printing them right now. I'm sorry, Ms. Rivera.
I can move, and we can get back to that part. Thank you, Madam Clerk. So thank you, Mr. Chair. I've had some time to mull over the various concerns raised by my colleagues, Mr. Gilliam and Mr. Falsey and Ms. Thino at our last meeting. Soon we're going to be getting some documents that I want to incorporate as an AIM to the AO, which clarifies some of these concerns. But before getting to those and before getting to some amendments, I want to really quickly review some of the elements in the AO. So the AO as amended in your packet contains 6 elements, all of which must be present for the immunity to apply. I'm going to go over those quickly. So first, the person must have witnessed or been a victim of a crime. Second, the person must have reported the crime to law enforcement. Third, the person must have made that report in good faith, which by definition is not someone holding a crime in their back pocket as an ace. Fourth, they must have made the report within a reasonable time. Fifth, that evidence that may support a prosecution of prostitution was obtained or discovered as a result of the person reporting the more heinous crime. So, seeing a crime as you're just walking down the street doesn't fulfill this clause. And finally, the person must cooperate with law enforcement ongoing from the time of reporting to conclusion. So I just want to repeat that all 6 elements of these must be present for the immunity to apply. So this AO is very narrowly crafted thanks to the hard work of Ms. Thino, Mr. Falsey, and Mr. Gates. Now, I guess I'll just move to my amendments until we get to those other documents. So I want to move Rivera Amendment number 1.
Moved and seconded, referred to as Rivera Amendment number 1, moved by Felix, seconded by Mr. Dyson. Do you want to go through it all, Felix?
Yes, thank you, Mr. Chair. So this amendment has 6 parts to it. So first, page 2, line 12 of the ordinance in your packet. It cites the correct code section on harassment. The original version had the incorrect code section cited. So thank you, Ms. Thino, for that correction, for that catch. Second is line 19. It adds in language to clarify that an alleged sex worker cannot ask for immunity based on a crime the individual themselves committed. I know that was a concern that Mr. Croft had. Third, line 29 deletes the language pertaining to the person initiating contact with police. Fourth, line 31 clarifies that the information must be of relevance to the investigation of the reported crime. Fifth, line 39 adds language to ensure that the alleged sex worker cooperates to the full extent possible and provides credible information to police. I know that's, again, another concern that was both presented by the prosecutor and by my colleagues. Last, page 3, line 7 adds in a new section 2, to clarify whether an alleged sex worker could report crimes prior to the effective date, and, for example, relating to the various unsolved murders of sex workers. So with that, I know that there are a lot of, and the documents are being handed out. So I will quickly go over those.
Yes.
Oh, apologies, I'm getting ahead of myself. Thank you, Ms. Domboski.
All right. So that was one amendment? Okay. Questions on that one amendment, comments from the body? Mr. Wilton, sir, on that first amendment?
Thanks. Looking at the wording on the new section 2, and I just want to, so when we use the phrase extends to, that means just say it also includes these things, right?
Correct. Yeah, so basically that phrasing, the immunity provided by the new code section extends to a report to law enforcement after the effective date of this ordinance relating to a crime occurring prior to the effective date. So at the last meeting, there were concerns brought up about some of the murders and, whether through this ordinance we would be able to bring forward, whether alleged sex workers would be able to bring forward to APD information about those murders. So I think this clause is trying to consider that.
Okay. Great. Thank you.
Any other comments from Assembly members on Mr. Rivera's First Amendment? Seeing none, Please vote on the First Amendment. Just waiting for you, ma'am. Yeah. Votes are all on the First Amendment. That First Amendment was approved, Mr. Rivera. Your next amendment, sir?
Thank you. So that is the only amendment I have. I just want to quickly go over the 3 documents that were given to each Assembly member. So first, there's a memo from Ledge Research Legal Services is the top of it in Juneau, when a version of this law was being considered and passed in the state legislature. It's by Hillary Martin, and Ms. Martin confirms that all elements must be present in order for a person to qualify for immunity. Also, if there is a disagreement on whether the immunity should apply, which sometimes does happen, the court would make the final determination. Another check for those concerned that some might take advantage of this law. Secondly, there's a memo by Mr. Baldwin, and it discusses the worry of the get out of jail free, which would go against 2 of the elements required, reporting in good faith and reporting within a reasonable time. And in this instance, Ms. Thino would have more than enough grounds to not give immunity if that was actually happening. And then finally, Mr. Oliver reviews the shortcomings of Crime Stoppers, which I know was something that was discussed at the last meeting, which was brought up as a suitable alternative to this AO. And in his memo, Mr. Oliver uses the example of someone anonymously reporting child porn through Crime Stoppers, and in that instance, the report would not be sufficient to obtain a warrant, and the person who has the child porn would have to willingly give their hardware to APD for inspection. So, with this immunity in effect, we would avoid these types of situations where Crime Stoppers isn't sufficient. So. That is all I have, Mr. Chair. I know that Ms. Thino has some comments, and I know my colleagues have plenty of questions for her.
Mr. Croft, sir, you next one in line.
I'll wait for Ms. Thino and get in line afterwards.
Okay. Seneca? Hello, ma'am.
Good evening. For the record, Seneca Thino, Municipal Prosecutor, and I'm here to answer questions. I didn't have any comments specifically that I wanted to offer tonight, but I'm available to help you with anything that I can.
Question from Assembly members. Ms. Dombrowski, ma'am.
Thank you, Ms. Thino. I don't actually remember my specific question I had last meeting for you, but let's just start with, as you read this ordinance and understanding how APD operates in their investigations and some of the prosecutions you've been involved with, what are some of the pros and cons you see potentially coming from this ordinance?
Through the chair, in terms of cons, I think one of the concerns is this idea that folks who are engaging in prostitution will use this provision to report things that may or may not be valid crimes or investigatable crimes in order to get out of something. That's certainly a concern that a lot of folks have expressed. I think it does, to some extent, interfere with the use of discretion. Law enforcement uses discretion every single day in terms of what to investigate, how to investigate, whether to charge someone, so on and so forth. Prosecution does the same. I think another con is that we create a special class of people in this context. So a special group of people that we believe has information and they're deserving of special protection that lots of other folks don't get. I think those probably are my primary concerns. In terms of benefits, I can't deny that if there is a person who has useful information, who for whatever reason is unwilling to come forward now, views this as a mechanism for encouraging them to come forward, certainly there could be some benefit there. But I'm not sure, I haven't seen that, so I can't speak personally to whether that is a benefit that will be realized.
Okay, and my last question is, considering the implementation of SB 91, is it necessary for the municipality of Anchorage to implement this ordinance?
Is your question in terms of whether the states applies to us or not?
Yeah, we talked about it some last year, or last meeting. And my understanding is, you know, even with SB 91 in place, which has aspects of this built into it, the municipality of Anchorage, if it wanted to, still could prosecute prostitution. But if we implement this, it's effectively mirroring SB 91.
Through the chair, it's similar to SB 91 or the provision in SB 91. It's not identical to it. The language does have some differences. With the state provision in place, that does not prohibit us from prosecuting a person under our prostitution code. The state would be prohibited from prosecuting under their prostitution code. So to have that protection, absolutely, then we would need this in our code. And that's something that we have learned over the course of the last many months, the last year, I suppose. And we've talked to some state colleagues about that to ensure that that's true. So that is factual. But I will say that we, like I said, always exercise discretion. And we would continue to do so whether this existed or not.
Okay, and just to make sure I understand this fully, there are some times when the state changes its laws that we have to change our laws to mirror theirs.
Yes.
This is not that case.
It is not.
Okay, and I said I had one last question. This is, I promise, my last question, unless I come up with another one. To your knowledge, can you remind us how many cases of prostitution we've actually charged in the last year?
When you say charged, do you mean arrested or actually charged by the prosecutor's office?
Charged by the prosecutor's office.
One since January of 2016.
Thank you.
Mr. Constant, sir.
Yeah, that actually brings up a question I've been pondering. Before that, how long was it?
Through the chair, I didn't run past January 1 of 16 to see what the date of our last one was. What I can tell you is that through the 90s and into the early 2000s, mid 2000s, prostitution was a fairly heavy focus for law enforcement, not heavy compared to everything else, but it was not uncommon for them to do stings or targeted approaches. And so I would say our prosecution rates of prostitution and solicitation were fairly high. I want to say, I have run those numbers before. I can tell you that there have been a couple hundred over that period. I couldn't tell you how many per month. What I can say is that starting in the mid-teens, the Anchorage Police Department, our office, the state, and a lot of other agencies started really taking another look at that focus and decided that focusing on trafficking and focusing on solicitation, the demand, was really a better place to put our resources. And so the investigations came down in numbers significantly. There are other reasons behind that as well, staffing and whatnot. But the investigations came down significantly. The charges came down significantly. And it's a dramatic drop that occurred, I want to say, around 2011, 2012, somewhere in there. So it has been steadily decreasing to the point that it's at now, which is arguably almost none.
So just a quick follow-up then, not to try to put on the soothsayer's hat and see the future, but do you think it's on the pendulum that this could come back and become a priority again at some time?
No, I don't. And the reason I say that is because, one, I think most people would agree that there are a lot of other things going on that really demand police attention. Two, since folks started talking about the idea of demand and supply, since folks started talking about the trafficking components, I don't know if it's a movement, but that emphasis, that concern, that focus has just spread immensely. And it is not only statewide, it's nationwide, it's international. And I think that comes from learning, from exposing something that had previously been occurring so much in the dark. And so I don't see any reason why folks would suddenly unlearn the enlightenment that they had had. We certainly now know a lot more about these kinds of cases and the circumstances. So no, I don't see us going back at all.
Mr. Croft, sir.
Yeah, Ms. Thino, so do you think this is an area better left to police and prosecutorial discretion?
Through the chair, 100%, sir.
And then sort of the other side of that, because I can see that point and that concern. I wrote down, or tried to write down, you said this is giving a special class of people, putting a special class of people deserving of special protection. Isn't that possibly true in this situation, that we do have a special class of people who are in fact deserving of special protection that we shouldn't write into our criminal code generally, but a class of criminal wrongdoers who are themselves victims and that this is one of the few or maybe the only place where this might be appropriate.
I would agree that it might be a unique class in the sense that there is a unique combination of both victims and perpetrators that fall into this group. I think a lot of folks might argue that that is true for drug dealers as well, certainly at the lower levels, that they are also users. But it is absolutely true that not everyone who is investigated or charged or prosecuted for this offense is a victim. And I think folks who are familiar with those entities or those people would argue that not all of them are necessarily victims. We have lots of people who have been victimized who are charged with lots of other crimes. And so trying to ascertain whose victimization is more significant or more worthy of protection, I think is difficult, and I think it gets us into a bit of a slippery slope, especially when you're putting that into code. I have mentioned this before, but there's a trend coming now to view folks who are charged with drug possession in a different way. We don't look at them as bad people. We look at them as people with a problem, and we try and really do a rehabilitative and treatment-focused handling of them. And it may be that in the future we look at those and say those are another special group that deserve protection because they might also have information and they're afraid of law enforcement for whatever reason. There are a lot of special groups that I think we could get to with special information. But I think, and obviously I'm partial to prosecutorial discretion, but I think that when you allow the folks who are most intimately connected to the people at issue and the crimes that they're dealing with and their personal lives, I really think you get the best results in that regard.
Mr. Croft, anything else?
Well, just the last one. I mean it. Unlike Ms. Dombosky, I mean it. Hopefully what we do up here usually is helping you and the police do their job. But in terms of trying not to get in your way, if we were to create, this is a good immunity one to write because you almost never prosecute this anyway. So we're unlikely to be getting very much in your way because we've picked a crime you almost never prosecute.
That is a fair statement.
All right, thanks. I have no more.
Thank you, sir. Mr. Peterson, sir.
Thank you, Mr. Chairman. I was wondering, are you aware of other jurisdictions where a similar law or ordinance like this has been used effectively to, apprehend or to arrest some criminals?
Through the chair, I am not, sir, and that is not because it hasn't happened. It's because I simply haven't researched that.
I see. Okay, thank you.
Mr. Wilton, sir.
Looking at this a little different, my impression on this thing is not, it's to make prostitutes comfortable with coming forward if they find something. So, and that's something you wouldn't know. Maybe a lot of them know stuff that you want to know now, and when this passes, should it pass, tomorrow you start getting calls. Hey, I know about this or crime or that one.
Well, I hope they don't call me. I hope they call EPD.
Or whoever, so they call, but they start calling, so there's presumably this information that prostitutes have because of the lives they live that would be good to know. And if this doesn't pass, it kind of makes your job easier when you might arrest someone or you say you want it up to your discretion, but should you arrest them for being a prostitute, this doesn't kick in. Because you arrest them for being a prostitute, they can't pull this out of their pocket and say, hey, I got this evidence. It would still leave it up to you to decide whether to charge them with prostitution or not. This is more about if before you ever have contact with them, you don't know they're a prostitute. But they come in and say, I know this, and the only way I know this is because I'm a prostitute. Then you have so it doesn't really get into that prosecutorial discretion area, I think.
Through the chair, I think in the perfect world, it would happen the way you described, which is an individual calls up APD and says, I have information, I need to tell you about something that's happening. I found it out because I'm working as a prostitute and one of my Johns knew X, Y, Z and I saw it and whatever, and off we go. I don't think the world necessarily works that cleanly so frequently, and so what I do envision, whether in the end it applies or not, what I do envision is running into litigation and questions about how to apply this appropriately to somebody who's being contacted by the Anchorage Police Department. Maybe they're being contacted for something unrelated to prostitution, an investigation ensues, and then they're like, oh, and by the way, this is going on, right? I mean, it's sort of those nitty-gritty details that it's not quite as clean as the scenario that you mentioned. Is it helpful if people give information to law enforcement? Of course, 100% it's helpful. And I find it unfortunate that people may have information about such really, really heinous crimes, and they're not willing or able, from their perspective, to provide that. But I do question whether that is going to result in a flood of information from the folks that have it to provide today. And I would say, again, from a discretionary perspective, if a person called APD, and I don't speak for them, but I think I can say with some confidence, if a person called APD and said, look, I witnessed a murder last night and I need to tell you about it. In the course of doing so, APD found out that that person was working as a prostitute at a hotel. I cannot fathom that the officer would say, thanks for the info and here's your site. I just can't fathom that. And quite frankly, if I saw that, it would stop with me. I don't think they would ever do it, and we would never proceed with it. And so I think the concern about what's happening is already being dealt with by the parties through their discretion. And so the only benefit that you're getting, I shouldn't say the only benefit, but it seems to me like the major benefit would just be that confidence, right, to a particular population. And I would also say that hopefully these conversations maybe have been enlightening to them as well about the circumstances of the world.
Okay, thank you.
Yeah.
There don't appear to be other questions from Assembly members. Thank you, ma'am.
Thank you.
Any other comments from Assembly members? Mr. Dunbar, sir.
Thank you, Mr. Chair. I just wanted to briefly commend Mr. Rivera and Mr. Dyson for bringing this forward. I think it is a needed reform and a good idea. I know I worked with Mr. Dyson back when he was Senator Dyson on other criminal justice reform proposals, and I know this is something he cares very much about. And I appreciate the work that Mr. Rivera has done with people like Ms. Thino over the course of the last couple of weeks. And what Ms. Thino said about, this change in the way we've been doing policing and the move away from prosecuting these kind of crimes, I think is much to the better. We now focus more on violent crime, and I think that's more appropriate. We have a finite amount of police resources, and that's where we should be concentrating them. So I intend to support this, and again, I want to thank my colleagues for bringing it forward. Thank you.
Mr. Croft and Ms. Dombowski. Mr. Croft.
Yeah, on the ordinance itself? No?
Yes, sir.
I'm not sure that this ordinance is legally needed. That is, I think Ms. Thino is right that this wouldn't be prosecuted. There aren't many prosecutions for this at all, and in the situations we're talking about, it seemed very unlikely that they would be prosecuted for the reasons that they'd be even brought forward by the police or chosen for prosecution by the prosecutor's department. So in a strictly legal sense, I don't know that this is very needed. I do think that some comments Mr. Weddleton made and others, that it's almost a communication or a confidence level. It is communicating that we would like you to do this, and that and to the extent that that gives an impression that it's okay, that's helpful. And it's not doing very much harm because there really aren't, again, that many prosecutions for this. So I do think that this is not something we want to do very often or maybe even ever again. And just the drafting of it kind of showed why. We all had in our heads a very similar, I think, idea of what we were trying to protect. It's very difficult to write it, and Mr. Rivera did a very good job of hearing things and doing, but you're trying to describe discretion, essentially. You're trying to describe what would be inappropriate to proceed with. And you know it when you see it, but it's hard to put into an immunity statute. I do think probably that this is a special class that is in need of this special type of communication and this unusual protection. And so I'll support it. I don't think it's something we want to be doing any more of maybe or a lot of, but in this area I'm convinced and we'll support it.
Thank you, sir. Ms. Dembowski, ma'am.
Thank you, Mr. Chair. I've really gone back and forth on this one because I do believe there is a value when someone has knowledge of a more serious crime to give them some sort of assurance that they're not going to be charged with prostitution, so they can so that law enforcement and prosecutors can get at the more serious crime. But I think there's this facade out there that all of a sudden you're going to pass this and you're going to have this floodgate. The floodgates are open and tips are going to come in. I don't think that's the case. So when I look at this from a criminal justice perspective, I'm looking at it like, what tools are you taking out of the toolbox? Because the one thing nobody's talked about is leverage. So when APD is investigating something and they have the opportunity to, they know something's going on, they have the opportunity to say to somebody, hey, listen, let's make a deal, whatever frame of that mind that person's in, it could be the leverage, because why would they do that unless now they know they're not going to be charged, but if they know they're not going to be charged for it, if something's tipped to them that there's a more serious, I don't know. I think there's a lot of guessing going on about what this might do. Frankly, I look at this kind of as, I don't want to say a feel-good ordinance, but it's an ordinance that I think you're trying to correct something that I think APD and the prosecutors are already doing. And frankly, the burden hasn't been met for me to hamstring what I believe could be good investigative techniques. So I'm not there. I won't be supporting it. But I do understand where you're coming from, and I think the basis is something we all agree with. I think we heard the municipal prosecutor saying, if somebody came forward with a serious crime, we're not going to turn around and charge somebody with prostitution. She said she's never seen it from APD, nor would she allow it to go forward. And I have confidence what she said is true. I also have confidence in the police department. I don't believe they abuse their authority. I think they use discretion, and I think discretion is a key part of policing. And so on this one, I'm standing. You just haven't met the burden for me, but I appreciate the conversation.
Thank you, ma'am. Mr. Rivera, sir, on your document as amended.
Thank you, Mr. Chair. So just want to make some brief final comments. I want to reiterate to my colleagues that 31 other states have passed similar laws to what we are looking at today. And as far as the research that Mr. Gates and I have done on this, this has been an effective tool by other jurisdictions to try to tackle that unknown, which I know a lot of folks are struggling with. There is a lot of unknown of how this effectively would this actually be used. I just want to also add for the record that in 2013 through 2014, in that 2-year time span, there were 34 charges of prostitution. So it's in actually recent history and recent memory of this community of these charges. So potentially there is a community that wants to do the right thing, and this is what this ordinance is intended to do, to allow this community to do the right thing, and I urge all of my colleagues to support this much-needed reform. Thank you.
Thank you, Mr. Rivera. Any other comments from Assembly? Mr. Dyson, sir.
Yeah, thank you, Mr. Chairman. I'm glad to be supporting this, but I want to be clear that my understanding of what I'm supporting is that a, quote, sex worker who's being beat up by a client or a pimp can report that crime of assault, maybe aggravated assault, without incriminating him or herself, because that abuse happened in the presence of another crime. Secondly, that if a sex worker dealing with a client, and the client is running his mouth and talks and bragging about crimes he has done, and so on, that the sex worker can report that and not be subject to prosecution on that specific act of prostitution with that specific client. Any other evidence that law enforcement might have about other sex crimes, I understand this worker would not be protected at. Only that single one, that knowledge of a crime of a significant higher order than the sex worker's crime. So I believe from Mr. Riviera and the testimony I've heard that my understanding of what we're doing is that. And those who have said, well, prosecutors can give people immunity. We're not talking about a hooker getting busted. This is not designed to be protection for him or her afterwards. It is to make it safe for them to be proactive on recording crimes that they know about, either by being a witness, victim, or perhaps hearsay. I'm done.
Thank you, Mr. Dyson. Any other comments from Assembly members before we vote on this? Seeing none, please vote. You're voting on the S version as amended. Let the minutes reflect that Mr. France has joined us. The item is approved 10-1.